ಬರೆದ್ರೆ ವಿ ಆರ್ ಆ ಅಮ್ಮನಿಗೆ ಅಗೌರವ ತಂದಂಗೆ ಆಗುತ್ತೆ. ನಾವು ಬರೆಯಕ್ಕಾಗಲ್ಲ ಆ ಥರ. That is only suspicion. It is not the case of the prosecution witnesses. Yes, there was illicit relation between these two. ಅವನೆಂಟು ಒಪ್ಪಲ್ಲ ಅಂತಾಳೆ. ಹೇಳ್ದ ಏನ್ರಿ ಅವ್ನ್ 3 ಜನಕ್ಕೆ ಹಂಗ ಹೇಳ್ತಾನೆ, ನಿನ್ ಗಂಡ ಹೆಂಡತಿನ ಬೇಕಾ ನನಗೆ, ಬೋಳಿ ನನ್ನ ಮಗ ಸಾಯಿಸಿದ್ದು ನೋಡು ಅಂತ. ಸಾಯಿಸಕ್ಕೆ ವೈ, ವಾಟ್ ದಿ ಮೋಟಿವ್, ಹಿಸ್ ಮೈಂಡ್. ಅವನು ಹೋಗಿ ಜಗಳ ಮಾಡಿ ಎಬ್ಬಿಸಿ ಅವ್ರ ಹೆಂಡತಿ ಮುಂದೆ ಜಗಳ ಮಾಡಿ ನನ್ನ ಮಗನ ಹಿಂಗ್ ಮಾಡ್ತಾ ಹಂಗ್ ಮಾಡ್ತಾ ಎಮೋಷನಲ್ ಆಗಿ ಹೊಡೆದಿದ್ರೆ ಕರೆಕ್ಟ್. ಅವ್ನ್ ಮಲಗಿದ ಮೇಲೆ ಹೊಡೆದ್ಬಿಟ್ಟ, ಅವ್ನು ಹೋಗಿ ಇವನು ಅವನೇನ್ ತಂದ ಹೊಡೆದ್ಬಿಟ್ಟ. ಆ ಹೊಡೆದ್ಮೇಲೆ ಅಮ್ಮನ್ಗೆ ಹೇಳ್ದ, ನಿಮ್ಮ ಗಂಡ ನನ್ನ ಹೆಂಡತಿ ಬೇಕಾ, ಬೋಳಿ ಮುಗಿಸಾಕಿದ್ದು ನೋಡ ಅವ್ನು ಇವಾಗ. ದಟ್ ಇಸ್ ನಾಟ್ ಪ್ರೊವೊಕೇಶನ್, ದಟ್ ಈಸ್ ಇಂಟೆನ್ಷನ್ ಟು ಕಿಲ್. ಮನೇನ್ ತಗೊಂಬತ್ತಾನೆ. ಪ್ರೊವೊಕೇಶನ್ ಯಾವಾಗ ಬರಂದ್ರೆ ಜಗಳ ಮಾಡ್ಕೊಂಡು ಇಬ್ರು ಅವ್ನ ಮನೆ ತರದೇನೆ ವಿತೌಟ್ ಇಂಟೆನ್ಷನ್ ತರದೇನೆ ಮನೆಯಿಂದ ಅವ್ರ ಕೈ ಸಿಕ್ಕಿದ ಯಾವ ಹೊಡೆದ್ರೆ ಅವಾಗ ಪ್ರೊವೊಕೇಶನ್. ಆ ಸಿಟ್ಟಲ್ಲಿ ಅವನೇನೋ ಬೈದ ಇವನೇನೋ ಬೈದ ಹೊಡೆದ್ಬಿಟ್ಟ ಅಂತ ಮನೇನ್ ತಂದವನೆ, ಮಲಗಿದ್ದ ಮುಂದೆ ನೋಡವನೆ. ನೋ ಇಂಟೆನ್ಷನ್ ಸರ್. Nobody's case except I am a complaint bitre, and he has not said anything. He says denial. ನೀವು ಹಂಗೇನಾದ್ರು ನೀವು T13 ನಲ್ಲಿ ನೀವು ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಹೌದು ನಾನು ಹೋಗಿ ಅವನ ಮಲಗಿದ್ದಾಗ ಹಾಕ್ಬಿಟ್ಟೆ, ಬೋಳೆ ನನ್ನ ಹೆಂಡತಿ ಬೇಕಾ ಅವನಿಗೆ ಅಂತ ಹಾಕಿದೆ ಅಂತ ನಮ್ದಾಗಿತ್ತು ಕೇಸು. ಅವನೇನು ಕೇಳ್ತಾ ಇಲ್ಲ, ನಾವು 2 ನಿಮಿಷ ಹಾಕ್ತಾ ಇದೀವಿ ನಾವು. ದಟ್ ಈಸ್ he set up by the other side and you are not admitting that. You said ಸುಳ್ಳು ಸುಳ್ಳು ಸುಳ್ಳು. ಅದ್ರ ಓದಿದ್ವಿ ನಾವು. ಏನಿಲ್ಲ ರೀ, ನಾವೇನ್ ಮಾಡೋದು. ಅಲ್ಲೇ ಹೌದು ಅಂತ ಮುದಾಗಿತ್ತು. ಈ ತರ ಅನುಮಾನ ಇತ್ತು ನನಗೆ, ಅದಕ್ಕೆ ಆಯಿಸ್ಬಿಟ್ಟೆ ಅಂದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿತ್ತು. ನೋಡಲ್ಲಿ ಕ್ವಶನ್ ನಂಬರ್ 19. ನೋಡ್ರಿ ಇಲ್ಲಿ ಕೇಳ್ತಾರ 19. ಬೇಬಿ ಇವರು ಬೇಬಿ ತಮ್ಮ ಸಾಕ್ಷ್ಯದಲ್ಲಿ ಈ ರೀತಿ ಹೇಳುತ್ತಾರೆ. ಕಳೆದ 2.5 ವರ್ಷದ ಹಿಂದೆ ಶನಿವಾರ ರಾತ್ರಿ ಸೋಮವಾರ ಸಮಯದ ಸದರಿ ನೋಡ್ತಿದ್ದಾಗ ಪ್ರಾಸವರ ಮನೆ ಕಡೆಯಿಂದ ಜೋರಾಗಿ ಬೊಬ್ಬೆ ಕೇಳಿಸಿತು. ಸದರಿ ಅವರು ಹೋಗಿ ನೋಡಿದಾಗ ಆರೋಪಿಯಾದ ನೀನು ಫಿರ್ಯಾದದಾರ ಮನೆ ಹತ್ರ ಇದ್ದು ಆ ಸಂದರ್ಭದಲ್ಲಿ ನೀನು ಫಿರ್ಯಾದೊಳಗೆ ನಿನ್ನ ಗಂಡನಿಗೆ ನನ್ನ ಹೆಂಡತಿ ಬೇಕಾ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿಂದ ಕತ್ತಿ ಸಮೇತ ಓಡಿ ಹೋದ ಎಂಬ ಸಾಕ್ಷಿ ಹೊಂದಿದ ಪುತ್ತ ಏನು ಅಂದ್ರೆ ಸುಳ್ಳು ಅಂತಾನೆ. ಹೌದು ಹೊಡೆದಾಕಿದ್ದಾಗಿತ್ತಲ್ಲ. ಹೌದಾ ಪ್ರೌಡ್ ಮಿಸ್ಟರ್
ಇಲ್ಲ 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದು ನಾವು ಹೇಳ್ತಾ ಇರೋದು
313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದು ನಾಟ್ ಚಾರ್ಜ್. 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಯು ಶುಡ್ ಹ್ಯಾವ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ನಾವು ವಿತೌಟ್ ದೇರ್ ಬಿಂಗ್ ಇನ್ ಎವಿಡೆನ್ಸ್ ಎಸ್ ದೇರ್ ವಾಸ್ ಇಲ್ಸಿಟ್ ರಿಲೇಶನ್ಶಿಪ್ ನಾವು ಬರೆದ್ರೆ ನಾವು ವಿ ಆರ್ ಗಿವಿಂಗ್ ಫೈಂಡಿಂಗ್ ಆನ್ ದಟ್ ಲೇಡಿ ಪಾಪ. ಅವ್ರು ಹೇಳ್ತಾರೆ ದಟ್ ಇಸ್ ದಿ ಅಲಿಗೇಷನ್ ಐ ಹ್ಯಾವ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಇಟ್ ಈಸ್ ಅಲೇಜ್ ಅಷ್ಟೇ, ಅದಕ್ಕೆ ಸಾಕ್ಷಿ ಇಲ್ಲ. ನನ್ ಆಫ್ ದಿ ವಿಟ್ನೆಸ್ ಸೇಸ್ ದೇರ್ ವಾಸ್ ಇಲ್ಸಿಟ್ ರಿಲೇಶನ್ಶಿಪ್ ಬಿಟ್ವೀನ್ ದಿಸ್ ಲೇಡಿ ಅಂಡ್ ದಿಸ್ ಮ್ಯಾನ್ ಇದ್ರೆ ಆಗಿತ್ತು. ಆತ ಇಲ್ವಲ್ಲ, ಅವ್ರ ಗಂಡ ಹೇಳ್ತಾಳೆ ಆತ ಇಲ್ಲ ನನ್ನ ಗಂಡ ಆತ. ಹೆಂಡತಿ ಬಂದು ಹೇಳ್ತಾಳೆ ತಪ್ಪು ಅಂತ. What to do, Karnataka? You have done your job. What to do? Yellide. If none of the evidence of the prosecution process, you crack the Malay, sourcing on NT. Already, you crack the Malay. ಅವನು ಸಾಯಿಸಿದ ಉದ್ದೇಶ ಎಂದು ಅವನಿಗೆ ಇವನ್ ಎಂಟಿನ ಅವನು ಇದು ಮಾಡ್ಕೊಂಡಿದ್ದ ಅದಕ್ಕೆ ಸಾಯಿಸಿದ ತೋರ್ಸಿಲ್ ಕಾರ್ಯಕ್ರಮ ಯು ಆರ್ ನಾಟ್ ಟೇಕನ್ ಡಿಫೆನ್ಸ್ ವಾಟ್ ಟು ಡೂ ಯು ಡೋಂಟ್ ಟೇಕ್ ಡಿಫೆನ್ಸ್ ಯು ಡೋಂಟ್ ಟೇಕ್ 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ನಾವೇನ್ ಮಾಡೋದು ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಕ್ ಬರ್ದಲ್ಲ ಕಾರ್ಯಕ್ರಮ ಅಲ್ಲಿ ನೋಡಿ ಅವರು ಇವನ್ ಎಂಟಿ ಇಟ್ಕೊಂಡಿದ್ದ ಒಂದು ಶಿಫ್ಟ್ಗೆ ಕೋಪ ಬಂದು ಮಲಗಿದ್ದವನು ಹೊಡೆದಾಕ್ತಾ ಅಂತ ಕಾರ್ಯಕ್ರಮ ಮಾಡ್ಬೋದಾಗಿತ್ತು ನೀವು ಮಾಡಿಲ್ಲ ಮಾಡಿದ್ರೆ ಮುಗ್ದೋಗಿತ್ತು 304 part 1 he can't control his mind lost his self control ಹೊಡೆದಾಕ್ದ ಅಂತ ಅದಿಲ್ಲ ನಾವೇನ್ ಮಾಡೋದು ಓನ್ಲಿ ಇಫ್ ಇಟ್ ಇಸ್ one case ನಾವೇನಾದ್ರೂ ಹಂಗ್ ಬರೆದ್ರೆ ಆ ಅಮ್ಮನ ಪಾಪ ನಾವು ಇದು ಮಾಡಕ್ ಅಷ್ಟೇ ವಿ ಡೋಂಟ್ ನೋ ಪಾಪ ಇನ್ನೋಸೆಂಟ್ ಲೇಡಿ ಆ ಅಮ್ಮನ ಯಾಕೆ ಕೆಟ್ಟ ತರ್ಬೇಕು ನಾವು ನಮ್ಮ ಫೈಂಡಿಂಗ್ ಶುಡ್ ನಾಟ್ ಬಿ ಬೇಸ್ಡ್ ಆನ್ ದಿ hearsay or some air should be some evidence ಹಂಗೆ ಹೇಳ್ದ ಅಂತ ಅವ್ರು ಹೇಳಿದಾರೆ ಅಮ್ಮ therefore ಇದು 302 it ಬಂದು ತಗೊಳ್ದ this is 302 not 304 part 1 part 2 ಅವನು ಅಲ್ಲೇ ಬಂದು ಜಗಳ ಮಾಡಿದ್ರೆ ಕತೆ ಬೇಡಾಗ್ತದೆ ಹೇಳ್ಬೇಕಾಯ್ತು 313 ವಾಟ್ ಟು ಡು ಸರ್ 30 ವರ್ಷ ಜೊತೆಲಿದ್ದೀವಿ ನೀವು ಸಾಯಿಸಿದ್ರೆ ನಾವೇನ್ ಮಾಡೋದು not ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಏನ್ರಿ ನಾವ್ ಅದೇನ ತೋರಿಸ್ ಮಾಡಕ್ ಆಗತ್ತೇನ್ರಿ ಅವ್ನ ಮಕ್ಳಿದಾರಲ್ಲ ರೀ ಇಬ್ರು ಮಕ್ಳಿದಾರ್ರಿ ಬರಲ್ಲ ನಾವೇನ್ ಮಾಡೋದು ಬರಂಗ್ ಮಾಡ್ತೀವಿ The class of the accused is the disease. Tally. How to That is not the evidence. Provocation yellow word elve. You should have cross-examined some of the witnesses or Gandanige, PW1 ನೋಡಿ ನಿನ್ ಗಂಡ ಈ ತರ ಮಾಡ್ಬಿಟ್ಟವನೆ ಪ್ರವೋಕ್ ಹಾಕಿ ಹೊಡೆದವನೆ ಅಂತ ಹೇಳ್ಬೇಕಾಯ್ತು ಹೇಳಿಲ್ಲ
188
ಎಸ್ ಹೇಳಿ MO4 Yes. Kodri. Chain.
MO4 ಕತ್ತಿ. Chain. Here and there. 1 over 2.
ಏನಿದೆ ಓದಿ statement. I'll take against the accused in favor of the accused. ಅಲ್ಲಿಗಿಲ್ಲ.
ಅವನ ಮೇಲೆ ಸಂಶಯ ಇತ್ತು. ಇದರಿಂದ ಬೇಸತ್ತ ನಾನು ಚುನಾವಣೆಗೆ ಕಾಯ್ದಿದೆ. ನಿನ್ನೆ ದಿವಸ ರಾತ್ರಿ ಚುನಾವಣೆ ಹಿಂದಿನಂತೆ ಹೋಗುವ ಉತ್ತೇಜಿತ ಉತ್ತರ ಬೇಲಿ ಸಭೆಗೆ ಹೋಗುವ ಅತ್ಯ ರಾಣೆಗಾರದಿಂದ ಚುನಾವಣೆಗೆ 5 ಮನೆ ಬಲವಾಗಿ ಬೆಳೆದ ಆಗ ಅವನು ತಕ್ಷಣ ಹೊರಗಿನ ಲೈಟ್ ಹಾಕಿ ಅವನ ಹೆಂಡತಿ ಮಕ್ಕಳು ಅಲ್ಲದೆ ಹೋಗಿ ರಾಟೆಗಣಕ್ಕೆ ಹೋಗಿ ಕತ್ತಿಯನ್ನು ಹರವಿಸಿದ್ದು ಕಾಫಿ ತೋಟದಲ್ಲಿ ಅರಿತುಕೊಂಡಿದ್ದೆ. ಈ ದಿವಸ ಮಧ್ಯಾಹ್ನ ಮಡಿಕೇರಿ ಕಡೆಗೆ ಹೋಗಲು 7ನೇ ಮೈಲು ಹಾಕಿಕೊಂಡಿದ್ದೆ. ಅದನ್ನು
Read 25, section 25. Evidence Act. ಇವಾಗ ಅವನು ನಿಮ್ಮ ಬೋಳಿ ನನ್ನ ಹೆಂಡತಿ ಬೇಕಂತ ಒಂದು ವರ್ಡ್ ಇದೆ. ಸೆಕೆಂಡ್ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ he has made a statement. ನನ್ಗೆ ಅವ್ರ ಮೇಲೆ ಇದಿತ್ತು ಅಂತ. We can't take ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ against him. ಬಟ್ ನೋಡಿ 125 ಕೊಡ್ರಿ. 25 ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ನೋಡಿ. ಕರೆಕ್ಟ್. In favor of this person will use now. Against ತಗೊಳಕ್ ಬರಲ್ಲ. But the word can be used in favor of this man. ಇಲ್ಲ ಹೇಳ್ತಾನೆ ನೋಡಿ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಓದಿ. ವಾಲಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದಿ ಸರ್. ವಾಲಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಾನು ನಮ್ಮ ತೋಟದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿರೋ ಸುಬ್ರಹ್ಮಣ್ಯ ಎಂಬುವರು ತೋಟದ ಜನರ ಹತ್ತಿರ ಅಲ್ಲಿ ಬೇರೆಯವರ ಹತ್ರ ನನ್ನ ಹೆಂಡತಿಯೊಂದಿಗೆ ಸಂಬಂಧ ಇಟ್ಕೊಂಡು ಸುಮ್ಮನೆ ಹೇಳಿಕೊಂಡು ತಿರುಗುತ್ತಿದ್ದ. ನೋ, ಇಟ್ ಇಸ್ ವಾಲಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದ ಅಕ್ಯೂಸ್. ವಾಲಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದು. ಈ ಬಗ್ಗೆ ನಾನು 4 ತಿಂಗಳು ಬಂದೆ. ನನಗೆ ಸುಬ್ರಹ್ಮಣ್ಯ ಮಾತಿನ ಜಗಳವಾಯ್ತು. ಅಲ್ಲಿಂದ ಅವನು ನಮ್ಮ ಬುದ್ಧಿ ಬಂದಿರಲಿಲ್ಲ. ಈಗ ಪುನಃ ಕಳೆದ 1 ತಿಂಗಳಿಂದ ಅದೇ ರೀತಿ ಹೇಳಿಕೊಂಡು ತಿರುಗುತ್ತಿದ್ದ. ಇದರಿಂದ ನನಗೆ ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ಆಗುತ್ತಿತ್ತು. ಮೆಂಟಲಿ ಡಿಸ್ಟರ್ಬ್. ಅಲ್ಲದೆ ಅವನ ಮೇಲೆ ಸಂಶಯ ಇತ್ತು, ಸಸ್ಪಿಷಿಯಸ್. ಇದರಿಂದ ಬೇಸತ್ತು, ಫ್ರಸ್ಟ್ರೇಟೆಡ್. ನಾನು ಸುಬ್ರಹ್ಮಣ್ಯ ಮುಗಿಸಬೇಕು ಅಂತ ಮನಸ್ಸು ತೀರ್ಮಾನ ಮಾಡಿಕೊಂಡು ಕಳೆದ ವಾರ ಕಾಯ್ತಾ ಇದ್ದೆ, ಹೊಡೆದಾಗ್ತಾ ಇದ್ದೆ. ವಿಲ್ ಟೇಕ್ ದಿಸ್ ರೆಡ್ಯೂಸಿಂಗ್ ಸೆಂಟೆನ್ಸ್. ಎಸ್ ಓದಿ. ಈ ಲಾಸ್ಟ್ ಇಸ್ ಕಂಟ್ರೋಲ್ ಸೆಕ್ಷನ್ 304 ಪಾರ್ಟ್ 1. ಜಗಳ ಅಂದ್ರೆ ಮಾನಸಿಕವಾಗಿ ಬೇಸತ್ತ. ಇವಾಗ ಯಾರೋ ಒಬ್ಬ ತಿರುಗ್ತಾ ಇರ್ತಾರೆ ಹೇಳ್ಕೊಂಡು ಅವನಿಗೆ ಅವಮಾನ ಮಾಡ್ತಾನೆ. He was mentally disturbed. That is the statement. ನೋಡೋಣ. Self control. He lost his control. ಇದು ಅದೇ ಆಗಿರೋದು. ನೋಡು, ಅವನಿಗೆ ನನಗೆ ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ಆಗ್ತಾ ಇತ್ತು 1, ಅವನ ಮೇಲೆ ಸಂಶಯ ಇತ್ತು 2. ಇದರಿಂದ ಬೇಸತ್ತು ನಾನು ಸುಬ್ರಹ್ಮಣ್ಯ ಮುಗಿಸಬೇಕು ಮನಸ್ಸಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡಿಕೊಂಡೆ. ಕರೆಕ್ಟ್. ರೀಸನ್ ವಾಸ್ ಇನ್ಸಲ್ಟಿಂಗ್ ಇಸ್ ವೈಫ್. ನಾನು ಇಟ್ಕೊಂಡಿದ್ದೀನಿ ಅಂದ್ರೆ ಅಡಲ್ಟ್ರಸ್. ಅವನು ಈ ಕಾಂಟ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಂಡತಿ ಇಟ್ಕೊಂಡು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವನು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಅವ್ರಿಗೆ ಪಾಪ ಆಟೋಮೆಟಿಕ್ ಇದಾಗ್ತಾನೆ, ಪ್ರವೋಕ್ ಆಗ್ತಾನೆ. ಸರ್, ಯಾರೋ ತೋಟದಲ್ಲಿ ಬಂದವರು ಅವನು ಹೇಳ್ಕೊಂಡು ತಿರುಗ್ತಾ ಇದ್ದಾನೆ, ಹೆಂಡತಿ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ ಅಂತ ಏನ್ರಿ ಅಂದ್ರೆ ಇವನು ಪ್ರವೋಕ್ ಆಗ್ತಾನೆ. ದಟ್ ಇಸ್ ದಿ ಪ್ರವೋಕೇಶನ್. ನಾಟ್ ನೆಸರಿ ಅಲ್ಲಿ ಹೊಡೆದಾಗ್ದಾಗ ಪ್ರವೋಕೇಶನ್ ಬರ್ಬೋದಾ? ಇದು ಪ್ರವೋಕೇಶನ್. ನೀವು ಕೋರ್ಟಲ್ಲಿ ಆನೆಸ್ಟ್ ದುಡ್ದು ಅಲ್ಲೆಲ್ಲ ಕಾಡಲ್ಲಿ ಇವ್ನು ಇಷ್ಟ ಮಾಡ್ತಾನೆ ಶಿಟ್ ಬರ್ತಲ್ಲ ನಿಮ್ಗೆ. ನಾಟ್ ನೆಸರಿ ಸರ್. Against him. But use it in favor of judgment ಇದೆ. Supreme Court judgment ಇದೆ. ಇಲ್ಲ ಬರೋಣ ವಾಲಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದಾಗ ಬರ್ತದೆ. ಅದೊಂದು ಇದೊಂದು all sections by warrant statement have to consider that no confession made with the police and it is better note that such provision does not have to use in that case confessions are sought to use in cases which such confessions would be used in the accused in a very few and there will be no exceptions under the take that ಅವನು ಅಮ್ಮ ಹೇಳಿರೋದು ಮುಂದೆ ನಿನ್ ಗಂಡನಿಗೆ ಉಳಿಬೇಕಾದ 1 ವರ್ಡು ಆಮೇಲೆ ದಿಸ್ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಟೇಕ್ ದಿಸ್ ಪಾರ್ಟ್ 1 ತೆಗೆದಿ. ಇಬ್ರು ಮಕ್ಳಿದಾರೆ ಸುಮ್ಮನೆ ಇವನ್ ಮಕ್ಳಿದಾರೆ. ನಾವ್ ಓದ ಇವನು ಹೆಂಡತಿ ಮಕ್ಳಿದಾರ್ರಿ. ಅವನ್ ಆತರ ಮಾಡಿದ್ರೆ ಪಾರ್ಟ್ ಮಂಡ ಹೋಗ್ಲಿ ಸುಮ್ಮನೆ ಅವ್ನು. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಒಂದು, ನಾವು ಬರ್ದಿದ್ವಿ, ಹುಡುಕಲ್ಲ ಮಾಡಲ್ಲ ನೀವು. ಸೆಕ್ಷನ್ 25 ಅಲ್ಲಿ ಯು ಕಾಂಟ್ ಟೇಕ್ ವಾಲಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಫೋರ್ ಪೊಲೀಸ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್. ಆದರೆ ಅವ್ನು ವಾಲಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇವನ್ ಫೇವರ್ ಆಗಿದೆ ಮಾಡ್ಬೋದು ಅಂತ ಇದೆ. ಅಪ್ಪ ನಾನು ಯಾವ್ದು ಮನೆ ಒಂದು ಮಾಡಿದ್ವಿ ಮನೆ ಟಿಕೆಟ್ ಆಗಿದೆ ಮಾಡ್ಕೊಂಡು ಬಾಬಾ ಯಾವ್ದು ತೊಂದರೆ ಆಗಿದೆ ಅಂತ ಕೊಡ್ಬೇಕು. ಬಾಮ ಸ್ವಲ್ಪ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ಬೇಕು ಸರ್, ಕೆಲಸ ಮಾಡ್ಬೇಕು, ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. The accused filed the present criminal appeal against the input judgment of conviction or sentence dated 19 September 2016 made in session case 54/2013 on the part of the first session district session judge Kodugu Madikeri, convicting the accused under the provisions of section 302 IPC, convicting the accused for imprisonment life with fine of rupees ಫೈನ್ 7,500 ಜಿಗಣ 7,500 for the offense of 2015 IPC. It is the case of the prosecution that the deceased P. Subramanian, husband of PW1, was propagating that he had illicit relationship with the wife of the accused, and there was a quarrel between the accused and this is in that regard. Since the accused suffered mental torture, suspected the character of his wife, accused had intention for committing the murder. This is thus on 9/2/2013 at about 10:30 p.m. the accused came to line house of PW1 at Bale Kadu Estate, Naragani village, when he said Subramani was sleeping on the cot in the veranda of his house, assaulted. He said Subramani with a sickle, MO4 and chin and murder him. Based on the complaint lodged by PW1 to the wife of the deceased as per Exhibit P1 on 10/2/2013 at 7:30 a.m. The jurisdictional police registered the crime number 10/2013 under the powers of 302 IPC. After investigation, the charge sheet have to put more than 9 years ಒಳಗಡೆ ಇದ್ದಾನೆ ಅವನು, ಆಲ್ರೆಡಿ 9 years. Against the accused on the powers of 302 IPC. After the matter was committed to learned session judge, the learned session judge secured the presence of the accused and framed the charge against the accused on section 302 for the offense pursuant to section 302 agrees to the accused in the language known to him, who pleaded not guilty, claimed to be tried. In order to prove the case of the prosecution, the prosecution examined PW1 to 20 and material documents MO1, exhibit P1 to P18 marked. Material objects MO1 to MO7 were marked. After completion of the evidence of prosecution witnesses, the statement of the accused as contemplated in the provisions section 313 CRPC was recorded. The accused denied all incriminating circumstances made against the prosecution witness against him, and he denied all the circumstances in toto and has not left any defense evidence on his behalf. Nekara. Based on the aforesaid pleadings, the learned session judge framed the point for consideration. Page 11 ಅಲ್ಲಿ ಒಂದೊಂದು ಹಾಕ್ಬೇಡಿ, ಪಾಯಿಂಟ್ ಪಕ್ಕ ಅಷ್ಟು ಮಾತ್ರ ಹಾಕಿ. Considering point for consideration agenda next para. Considering both Warren document evidence on record, the learned session judge answered the point in affirmative, holding that the prosecution proved beyond reasonable doubt that Subramani was propagating that he was having illicit relationship with the wife of the accused, and the accused suspected the character of his wife, and with the intention to kill the said Subramani came near his line house on 9/2/2013 about 10:30 p.m. When Subramani was sleeping on the cot in the veranda of his house, assaulted with a sickle MO4 on his right neck and chin, murder the deceased, thereby committed offense punishable with provisions of section 302 IPC. Accordingly, the learned session judge, by the input judgment of court of sentence, convicted the accused for imprisonment of life with fine of rupees 7,500 for the offense punishable with provisions of 302 IPC. Hence, the present appeal is filed. We have heard the learned counsel for the power distribution. Karnataka. P. Learned counsel for the appellant contended with vehemence that the impugned order passed by the trial court convicting the accused on section 302 IPC is erroneous, contrary to material record, cannot be sustained. He would further contend it that there are no eyewitness to the incident occurred on 9/2/2013 at about 10:30 p.m. The complaint was lodged next day morning on 10/2/2013, 7:30 a.m. was not explained by the prosecution. Thereby, the delay is fatal to the case of the prosecution. He would further contend it that evidence of prosecution witnesses are not corroborating with each other and they are contrary to each. In spite of same, the trial court convicted the accused for the offense for 1502 IPC erroneously. He would further contend it that the conviction of the accused based on the presumption, not based on any cogent evidence. The prosecution has not made out any ground to take extreme punishment of 302, imprisonment of life under section 302 IPC. Thereby, the session judge proceeded erroneously convicted the accused. He would further contended that according to the case of the prosecution itself, that this is Subramani, husband of PW1, was propagating in the village that he had illicit relations with his wife of the accused, and there was a quarrel between the accused and the deceased. Thereby, the accused suffered mental torture, suspected character of wife, and thereby he lost self-control and murdered the deceased on 9/2/2013 at about 10:30 when he was sleeping on the cot near his house. Thereby, it's a clear case of attacks the provisions of section 301 part 304 part 1, and not on the provisions of 302 APC. Therefore, he sought to allow the appeal. For contrast, Sri Majge, Leonard Counsel for the Leonard SPP, while justifying the input judgment of conviction out of sentence, content that the very complaint exhibit P1 clearly depicts when the deceased was sleeping near his house, near his veranda of his house on the cot at about 10:30. The PW1, 2, and 3. The screaming sound came out. My mother. Shown by the deceased came out of the house and seen that the accused was standing near the deceased, holding M4 sickle on his right hand, on his hand. Thereafter, as soon as Dhanalakshmi, PW6, and Punit Tero, Punit, Punit, PW4, Dhanalakshmi, PW5, PW6 baby came. He went away about to the garden along with the sickle. And to that effect, PW1, PW2, and PW3 categorically stated on oath that the accused intentionally murdered the deceased without there being any cause. He would further contended the evidence of the clearly depicts that without there being any provocation, with an intention to murder, come out about 10:30 when the deceased was sleeping in the veranda on his cot, the accused intentionally came to the spot and mercilessly attacked about 7 injuries, 30 injuries. Injuries in grievous nature was caused. Thereby is a clear case of murder for to attack the province of section 302 IPC. The same is evidence by the evidence of the doctor PW14 and PM report exhibit P8 and the FSL report exhibit P15 clearly depicts that the accused involved homicide death of the deceased. Therefore, the trial court was justified in convicting the accused under the province of section 302 IPC 5, not IPC, not dismissed. The appeal. Next. He also contended, he also contended that the accused, the sickle exhibit report, MO4, was recovered by investigation officer PW A, at the instance of the accused, thereby recovery proved, intention proved, thereby the trial court has justified convicting the accused of the offense of 15 or 2 IPC. Therefore, sought to dismiss the appeal. Next part. In view of the relevant contents has been level counsel for the party. The only the point that I have consideration is the present appeal is that the trial court is justified convicting the accused under the provisions of section 302, imprisoned life with fine of 7,500. The facts of the case and whether the accused has made out a case to interfere with the impugned judgment of conviction and modify to reduce the sentence awarded by the trial court in the fact and circumstances of the present case. Next time. We have given our thoughtful consideration to the arguments advanced by learned parties and perused the entire material record carefully. The court, being the appellate court, in order to reappreciate the entire evidence on record, it is relevant to consider the evidence of PW's prosecution witnesses and the material document laid upon 1 A, B separate. PW1, Pungawa, with the wife of the deceased Subramani, and the complaint deposed that since 30 years they are staying in the line house of Alekadu estate. There only. Accused also working inside the estate since last 10 years. And also stayed along with his wife, 2 children, and another line. The distance of 10 feet from the line of the house of PW1. During 2013, PW3, who is the son of PW1, was studying in the second piece at Medicare. By staying in a line house about 2 to 3 years back, there was a quarrel between the accused and the deceased. About 2 years back, PW1 then was in her house along PW2 and 3. At about 9:30 p.m., deceased had a dinner, slept on the cot in front of veranda of their house. PW1 and 2 slept in the middle room. PW3 was studying inside room. At about 10:30 p.m., she heard her husband shouting, screaming. Immediately, she switched on the light, and came outside the house along with the PW2 and 3. Saw the accused holding sickle MO4 in his hand, standing near the deceased. When PW1 asked the accused as to what happened, the accused stated that he had murdered the deceased since deceased has having illicit relationship with his wife. At the time, PW4 to 6 came there and the accused ran away from the spot. He supported the case of prosecution by lodging, according to lodged the complaint exhibit P1 and identified MO 1 to 3 photographs under exhibit P2. Sickle use was also identified MO 4, supported the case of the prosecution. In the cross-examination, she admits that the accused was cordial with them and there was no enmity between the accused and the deceased. She has not informed police about any quarrel between the accused and deceased prior to the incident. The deceased never had any illicit relation with the wife of the accused. So-called case of prosecution. PW2 Sandhya, who is the daughter of PW1, and the son deceased and the deceased Subramani. The repose on par with PW1. Supported the case of the cross examination. Case of the support case of the PW1. The repose on par with PW1, thereby supported the case of prosecution. In fact, he denied that deceased had a habit of consuming alcohol. His assertion made by the examination. PW3, Santosh, PW2, Sandhya. Santosh, son of the deceased, and PW1 also deposed similarly on par with the accused number, on par PW1 and 2. Supported case of the prosecution. PW4, Punita, who deposed, was also residing in the line house of Balekadu estate along with her husband and children. When the house of PW is situated in between her house and house of PW5. The house of the accused situated at a distance of about 150 meters from her house. For 4 months, prior to the death of the deceased, there was a quarrel between the accused and the deceased. Between the accused and deceased. About 2 years back, at 10:30 p.m., when PW4 heard PW shouting from her house, PW4 to 6, who heard PW shouting, immediately went near the house of PW. At that time, the accused had assaulted the deceased and was going towards the estate by holding sickle in his hand. So for case of prosecution. PW5, Dhanlakshmi, who reports that 2 years back on Saturday, about 10:30 p.m., when she was watching television after finishing her dinner, at that time she heard somebody shouting, Amma. Immediately, Amma, not Kamadali. Came out of the house, she saw the accused standing near the sickle, standing near the deceased with sickle. After having murdered the deceased, there's distance of about 5 feet from the house. When people asked the accused what happened, the accused replied that stating that deceased had only wanted his wife having illicit relationship. Therefore, he murdered him. Support a case of prosecution. PW6, baby, post on par with PW4 and 5. Support the case of the prosecution. This is covered actually. Like that. PW7 Rajesh reports that about 2 years back, in the month of February at about 10:30 p.m. to 12 p.m. midnight, PW3 called him stating that somebody had assaulted his father. Requested him to bring his chief. Accordingly, he came along with the PW8 and CW10, saw the deceased sleeping on the cot in front of the house. There were injuries and disease on his neck and hand. Immediately they were taken to the Vivas Hospital, Madikeri. The doctor who examined stated that this is brought dead. He identified MO4 sickle and also she's the mother witnesses. Supported the case of prosecution. PW8 Ravina reports that about 2.5 years back, between 10 to 10:30 p.m., PW7 called him over for informed that a murder had taken place near the house of PW1. He went along PW7 and showed the house of front veranda of the house of PW1. The deceased was laying on the cot. His neck, chin, and hand was injured. All of them took the deceased to Vivas Hospital, Madikeri, along with the jeep belonging to PW7. Supported the case of the prosecution. And I also witnessed the mother of the MO12 class of the deceased, the MO1 to 3, Caesar and the exhibit P5, mother. Support the case of the prosecution. Then PW9 Arish, who deposed during the year to the deceased Subramani, had expired, and they have seen his dead body in the mortuary Madikeri Government Hospital. The injury was on neck of the deceased. Police conducted Maja for exhibit P6. In presence of inquest Maja exhibit P6. In presence of PW9, PW11, PW12 in the hospital. He denied that the exhibit P5 Maja conducted by the police. The clothes of the deceased MO1 to 3 were seized by the police in his presence. He admits that he does not know the content of exhibit P6. Support the case of prosecution. PW10 Vasu reports that during the year 2013, the police came to the house of PW1 and conducted a march at exhibit P3. He does not know the place of the incident place Police have seized the blood-stained bed sheets, number 5, which was on the cart in the veranda of period 1. During the car examination, admit that the distance between the Suntokappa and Balekadu is about 2 kilometers. Does not know PW children. Support case at prosecution. PW 1, 11 Shashi reports about 2 years back, police had came near the house of PW 1 at 12 noon and seized the blood-stained bed sheet, number 5, conducting Majar as per exhibit P3 in his presence. During Karnataka examination, admit that is not know to read and write Kannada language. But does not know the content of exhibit P3. Support case of prosecution. PW 12 Rajan, who reports that on 10/2/2013, between 3 p.m. to 3:30 p.m., Kantikappa police called him to the police station and the accused was present at the time. Police asked the accused to change his clothes that was worn by him at that time. For committing the murder of the deceased, the blood were blood stained. There the police conducted Major exhibit P7, seized the blood-stained clothes of the deceased as clothes of the accused, MO 6 and 7 in his presence. During the car examination, admits that he does not know to read and write in Kannada language. The clothes of the accused were handed over to the or in the hands of police. He admits that similar MO number 6 and 7 are available in the shops. Support case of prosecution. PW 13, G. Ramana has deposed that about 1 year back, on Saturday in between 5:30 to 6 p.m., the accused has produced one sickle kept by him in the drying yard. The said sickle was found near the drain of the said drying yard. The police conducted a exhibit P6, seized exhibit P4, seized the said sickle MO4 in his presence. During car examination, admit that he does not know read write in Kannada language, and the area within the fence of drying yard is cemented, and each drying yard has been drainage. He admits that there are several lives like MO4 in their estate. Supported the case of the prosecution. PW 14, Dr. Kumar is the medical officer at Medicare Government Hospital, deposed at 10/2/2013 at about 12 noon. Deceased was brought to the hospital by Shantikappa police station, conducting postmortem examination. As per the requisition made by the police, PW 14 conducted postmortem report from 12:30 p.m. to 2:30 p.m. Issued PM report exhibit P8. Find that the injuries could be caused by using similar weapons like the sickle. The support case of prosecution. PW 15, Junior Chandrappa, junior engineer, Karnataka Electric Supply Center, has deposed that they issued the exhibit P10 certificate certifying that there was electricity supply on 9/2/2013 at Shantikappa at about 10:30 p.m. During the exam, admits that the registrar maintained in their office on record the timings and the electricity switch trips. They admit they had not given extracts of ledger to the police to show the electricity supply Shantikappa was on that day. Support case of prosecution. PW 15, Mahendra Kumar, to depose that on 12/2/2015 he received letter from the Second Inspector Vishal Naga to visit the police place of the incident on purpose of the spot sketch. Accordingly, on 18/2/2013, he prepared the spot sketch of visiting the Balekadu estate as by exhibit 11. Nothing much is illustrated with the examination. PW 17. PV Satish, who reports that on 10/2013, the PSI had deputed him to guard the dead body of the deceased. Accordingly, came to the hospital, mortuary, and CW 28 conducted inquest measure in his presence and also submitted requisition to the doctor through PW 7 for conducting postmortem examination. The doctor handed over the cloths of the deceased within bracket MO13 of conducting postmortem report, which produced by PW 17, post CW 29. Thereafter, CW 29 conducted Maja Exhibit P5 and seized such cloths of the deceased and denied all versions support case of prosecution. PW 18, Chandrasekhar, who deposed that on 10/2/2013, he arrested the accused at Kadakal near 7th Main bus stop. He and P27 gone to the said place at about 3 p.m. He arrested the accused based on the credible information produced before the exhibit CW 29 along the report exhibit P12. With the examination admits that he had not inquired with the accused about his whereabouts since the morning. Nothing is also examination. There is support case of prosecution. PW 19, SP Krishna Kumar, who deposed that on 10/2/2013, PW came to the police station, submitted a return complaint to exhibit P1. Based on exhibit when he registered the FIR, base number 10 of 2013, as per exhibit P13, he deputed PW 17 to guard the dead body of the deceased and also repeated PW 18, PW 27 to arrest the accused. He further deposed that he went from the government hospital to conduct inquest measure on the dead body of the deceased, exhibit P6. In terms of CW 11, 12, 14, 15, and 9, who recorded statement of said persons, and also inquest procedure was recorded. He sent a requisition to the doctor through PW 17 to conduct postmortem examination. Accordingly, the support case of prosecution. PW 20, KL Ganesh, GP, Kushal Nagra, Circle, who deposed that he took up the investigation from PW 19 on 10/2/2013. On the same day, PW 18 produced certified copy before PW 20, along with the report exhibit P12. The police seized the clothes of the accused MO67, connected mother exhibit P7, in presence of witnesses. Thereafter, the accused led the police Balakad estate Kandukupa, where he had hidden MO4 sickle in the drainage beside the drying yard and produced it. The said sickle was blood-stained, and the police seized the same by conducting measure as per exhibit P4 in presence of the Panchas. For case of prosecution. Based on the appropriate material on the record, the learned session is proceeded to convict the accused. For the appropriate following subsequently not to IP. Next up. Here, consideration of the complaint exhibit P1 by the PW1 specifically stated that on 9/2/2013 about 9:30, after dinner, the PW1 and Sandhya, PW2 went to sleep in the room, and the PW3 was studying, and accused went to veranda, sleep. As usual, as about 10:30 p.m., they heard this sound of her husband screaming. Accordingly, PW1, PW2, PW3 went to spot. By the time they saw, the accused was standing near the deceased with holding MO4 sickle in his hand. First up, the categorically PW1, PW2, PW3, PW4, PW5, PW6, PW7. Suppose that there was a quarrel between the accused and his. In fact, a suggestion was made to the defense counsel that to the PW7 that there was a quarrel between the accused and deceased. It is also not in dispute when PW1 questioned the accused why he has killed his husband, her husband. The accused replied that ನನ್ನ ಹೆಂಡತಿನೇ ನಿನ್ನ ಗಂಡನಿಗೆ ಬೇಕಾ, ಇವತ್ತು ಅವನನ್ನು ಮುಗಿಸಿಬಿಟ್ಟೆ ಬೋಳಿ ಮಗನೆ ಎಂದು ಹೇಳಿದ. ಹಂಗೆ ಕಾಣ್ತಾರೆ ಬಗ್ಗೆ ಬ್ರಾಕೆಟ್ ಹೇಳ್ಬೇಕಾದ್ರೆ since the disease of propagating that he had illicit relations with the wife of the accused, there was a quarrel between the accused. The accused mental suffered suspect the character of his wife, thereby has committed the murder of the deceased. The doctor who examined the dead body of the deceased about the case of prosecution about the homicide death of the deceased. Accordingly, he issued the Exhibit P8 EM report, and there were 4 external injuries and 2 wounds, 2 deep 2 wounds presently, and opined that the cause of death was due to shock and hemorrhage, the result of multiple injuries sustained. Stop. The FSL report, exhibit P. The FSL officer are Madila.
Exhibit P16.
The exhibit P16 FSL report, though the officer was not examined, exhibit P16 is produced the FSL report, which clearly indicates that the presence of blood was directed item number 1, 2, 3, 4, 5, 6, and 7. Item number 2, 1, 2, 3, 4, 5, 6, and 7 was stained with human blood. Item number 1, 2, 3, 4, 5, and 6, and 7 was stained with who bled. The description of the articles: one bedsheet, one pant, one t-shirt, one katti, one shirt, one pant, one chaddi. The cause of the disease and the accused was also recovered. Thereby, the blood stains was also existing not only at cloths and also on MO4 sickle. So, the session proceeded to convict the accused under the clause of 302 IPC, ignoring the material evidence of PWs 1 to 8, who clearly deposed that 1 to 7, who clearly deposed that there was a quarrel between the accused and deceased earlier occasion. As the deceased Subramani, husband of PW1, was propagating that he had illicit relationship with his wife, the accused, and there was a quarrel between the accused, and the accused frustrated and mentally tortured and suspected the character of his wife. Thereby, has killed the deceased with MO4. Accordingly, as stated. Accordingly, he has stated that ನನ್ನ ಹೆಂಡತಿ ನಿನ್ನ ಗಂಡನಿಗೆ ಬೇಕಾ, ಇವತ್ತು ಅವನನ್ನು ಮುಗಿಸಿಬಿಟ್ಟೆ ಬೋಳಿ ಮಗನ್ನ. ಅದನ್ನ ಹಾಕಿ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡಿ, ಕನ್ನಡದಲ್ಲಿ ಹಾಕಿ ಕನ್ನಡ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್. The careful reading of the evidence of past witnesses, they accept the alleged illicit relationship with the wife of the accused, and there is a quarrel between the accused and deceased. There is no other motive proved by the prosecution. That is the motive for the murder. Stop. In 313, though the accused denial, total denial in 313 statement recorded by the prosecution, by the court, he has totally denied all incriminating circumstances. He has not deposed that how it happened. Stop. In the absence of any explanation offered by the accused, why he has killed the deceased, an adverse inference has to be done against the accused. Our view is 45 with the Honorable Supreme Court in the case of so and so Prahalad, 2019, so and so, paragraph 11, held as an. Stop. It is also relevant to state at this stage that apart from the evidence PW1, PW2, PW3, PW4, PW5, PW6 and 7, that there was a quarrel between the and the deceased's earlier occasion, as the deceased, the husband of the PW1, was propagating that he had illicit relationship with the wife of the accused, and thereby the accused mentally was suffering and was suspecting and frustrated. The words used by the deceased in the village about his wife. Thereby, he has taken the extreme step to kill the deceased, as admitted by him in the evidence, admitted by him in the voluntary statement made under section 161 before the police. Put up. The provisions of Section 25 of the Evidence Act, in concern with the voluntary statement, has to consider that no confession made to a police officer under Section 161 Code of Procedure, Criminal Procedure, shall be proved against the person accused of any offence. No confession to any offence. It is pertinent to note that the said provision does not prohibit the use it in favor of the accused. In the majority of cases, the confessions are thought to be used only against the accused. The cases involved, the cases in which such confessions would or can be used in favor of the accused will be very few, and there will be exceptions to the general rule. In other words, where the accused stated that he killed the deceased on provocation, as mentally suffered, disturbed, there is no point. As he was suffering mentally, and he was suspecting the disease, and he was frustrated. The words used, the frustrating about the disease, the husband of PW1 was propagating that he had relationship. Thereby, he has involved homicide death. The provisions of the said section only prohibits use of confession against an accused, does not prohibit use in his favor the accused. Thereby, the voluntary statement exhibit tester or exhibit 314 is supported by the other corroborative evidence, namely the evidence of PW 1 to 7, as the words used by the accused when he was holding sickle MO4 along with the deceased in front of PW 1 to 3 clearly depicts that because of the propagating words by the deceased, he lost his self-control. Thereby, this case clearly falls under the provisions of exception 1 of Section 300 Code of Civil Procedure. The said material fact has not been considered by the learned session judge. Exception 1 of Section 300 reads as an. A careful reading of said provision makes it clear that culpable homicide is not a murder. The offender, while deprived of the power of self-control by grave and sudden provocation, causes death of a person who gave the provocation, causes death of another person by mistake or accident. Admittedly, in the present case, it is the specific case of the it is specific evidence of the PW 1 to 7 that there was a quarrel between the accused and the deceased. It is also specific government made by PW 1 to 3 with the wife and children of the deceased that the deceased, after killing the accused, was standing near the deceased with the MO4 sickle when the PW1 asked why he has killed, he uttered words uttered word that your husband wants my wife. Today I have finished that roster. And also stated in his voluntary statement under exhibit P14, exhibit 14, recorded under 161 CRPC. Thereby, the clear case falls under the provisions of section 304 part 1 and not under 304 part 2, 302 IPC. The said material evidence is not being considered by the learned section judge. Stop. Considering the after reassessing the entire material and record, this court convinced that the case clearly falls under the province of 304 part 1 IPC, taking into consideration that the deceased, the accused, also wife and 2 children, and taking into consideration mitigating circumstances that in fact has suffered the judicial custody more than 9 years, and considering the material record, peculiar facts and circumstances, where the considered opinion, this was a case of provocation, where the provocation was kept in mind by the accused, thereby in 313 statement has specifically stated that he was suffered mentally. 161 161 specifically stated there we have specifically stated that due to the propagating the words in the entire village by the deceased that he had illicit relations with his wife of the accused, though there was a quarrel, thereby he was mentally, he was mentally suffering and was suspecting and was frustrated, thereby he has killed the deceased. And the same words was used to the PW1 who witnessed that the accused was holding sickle and standing in front of the deceased as spoken to by PW1 to 3, the wife, children of the wife and children of the deceased. The said material also not considered by the session judge or convicted accused for the offense of 1502 IPC. Next one. For the reason stated above, the first point raised in the present appeal is answered partly in affirmative, partly negative, holding that the trial court is not justified convicting the accused for the offense special provisions of 1502 IPC with imprisonment of life, fine of 7,500. And the second point is answered in the affirmative, holding the accused has made out a case to interfere with the impugned judgment of conviction out of sentence for trial court and to reduce into 304 part 1 IPC. Next paragraph. In your above, we pass the following on. The appeal is allowed in part the impugned judgment of conviction of sentence passed by trial court convicting the accused for imprisonment of life with fine of 7,500. The provisions of section 1502 is modified. The accused, he will announce the fine. ಆ ಮಕ್ಕಳಿಗಾದ್ರು ಕೊಡ್ತೀವ್ರಿ ಬರೀ 7,000 ಎಸ್ ರೀಸನಬಲ್ ಕಾಸ್ಟ್. ಇಬ್ರು ಮಕ್ಕಳಿದಾರ, ಅವನು ಹೆಂಡತಿ ಮಕ್ಕಳಿದಾರ, ಹೆಂಡತಿ ಮಕ್ಕಳಿಬ್ರು ಕಾಂಪನ್ಸೇಟ್ ಕೂಲಿಂದ ಒಳಗಡೆ ಬಿದ್ದಿರ್ಲಿ ಬಿಡಂಗ ಅದು ಇರ್ಲಿ the accused is be convicted under the provisions of section 304 part 1 and he has to undergo imprisonment for a period of 10 years with fine of rupees 15,000 with report class 2.5 years. The accused is entitled the benefit of setup as controlled in provisions of section 428 Code of Proceedings. Out of the amount, I involve the provisions of section 357, bracket 3, Code of Procedure. The amount of fine amount deposited to be deposited by the accused 14,000 shall pay to the PW1, the wife of the deceased, and remaining 1,000 shall be used for expenses of deploying the expenses. State for deploying expenses. So an observation made by the Learned District Judge while allowing the application filed under section 357A of the Code of Procedure recommended the state district legal society to pay victim compensation to PW1 Ungawa. Apart from the compensation, she is entitled out of fine amount. If he said the victim compensation not paid, the concerned district legal society hereby directed to ensure that the PW1 and the two daughters, PW1 is entitled the reasonable compensation, victim compensation in accordance with the chart prepared by the state legal society. I dismiss since the main matter itself disposed upon merits. Year 1, year 2, 2017 would not have for consideration. ಸ್ವಲ್ಪ ಕೆಲಸ ಮಾಡ್ಬೇಕು ಸರ್, ಹುಡುಕ್ಬೇಕು ಸರ್, ಲಾ ಇದೆ ಸರ್, ಹುಡುಕ್ಬೇಕು ಸರ್. ಇದು ರಿಫಾರ್ಮೇಟಿವ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಒಂದು ಅವಕಾಶ ಕೊಡಕ್ಕೆ ಅವ್ರಿಗೆ ಪ್ಲಾನ್ ಮಾಡೋದು. ನಾವು ಏನಾದ್ರು ಹುಡುಕ್ತೀವಿ, ನೀವು ಹುಡುಕೋರು ಬರ್ಬೇಕು. ಎಸ್ ಸರಿಯಪ್ಪ. ಎಸ್ ರಾಜು ಏನಪ್ಪ ಬರೋಲ್ಲ, ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಹೇಳಿ. ಎಷ್ಟು ಸಲ ಆಗೋದು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನೋಡೋಣ. ಯಾರ ಬಂದ್ರೆ ಅವ್ರು ನಾವು ಇಲ್ಲಿ ಅಪಾಯಿಂಟ್ ಅಮ್ಕೆಸ್ಕರಿ ವಾಟ್ ಇದು ಗೊತ್ತಾ ಇಲ್ಲ, ನೀವು ಬರಲ್ಲ. ಹೋದ್ಸಲ ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಗೆ ನಾವು ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವ್ರು ಬಂದ್ಮೇಲೆ ಮತ್ತಲ್ಲ ಸಿನಾಪ್ಸ್ ಹಾಕ್ತೀವಿ ಟೈಪ್ ತಗೊಂಡ್ರಿ, ಸಿನಾಪ್ಸ್ ಹಾಕಿಲ್ಲ ಕೊಡಿ. Will appoint somebody what to do. Already not appearing. ಬದಲಾಗಿ ಅದೇನು ಅದ್ರಲ್ಲಿ ನೀವು ಹಾಕಿದ್ದೀರಿ ಸ್ಟೇಟ್ ಅಪೀಲು. ಇದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ನಾ ಏನು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 201 ಇವ್ರಿಗೆ ಲೈಫ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇವ್ರು ಕೊಟ್ಟಿಲ್ಲ. ಅದು ಯಾರು ಬರ್ಬೇಕಲ್ಲಪ್ಪ ಅದು. ಎಕ್ಸ್ಪ್ಲೋಸಿವ್ ಸಬ್ಸ್ಟೆನ್ಸ್ ಆಕ್ಟ್, Explosive Substances Act 201. It's spite of repeated judgments None appears for the accused in criminal appeal 13/78/2019. There are no option except to appoint Amkesh Puri from the panel of High Court Rules Committee. Srimati P.V. Kalpana, the advocate on the panel of High Court is appointed to assist court at Amkesh Puri. The SPP directed serve copy of the same to the learned Amkesh Puri forthwith next week. And ಯಾರಾದ್ರೂ ಇಟ್ಕೋಬೇಕಪ್ಪ ಸುಮ್ಮನೆ ಜೂನಿಯರ್ ಇರ್ತಾರೆ ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡೋದಾಯ್ತು. Yes, Sumati. Case called thrice, none appears as appellant, even though the matter is of 2017 and the accused is languishing in jail. Still, the counsel for the appellant has not shown institutional responsibility and constitutional obligation towards his client. Hence, you have no option except to issue court notice to the appellant. Court notice to the appellant to concerned jail superintendent, and the appellant shall ensure to appoint separate advocate, or he can seek free legal aid from the Karnataka Legal Service Authority. Yes. ಇವರೆಲ್ಲ ಎಲ್ಲಿಂದ ಬರ್ತಾರೆ? ಕೇಸ್ ಕಾಲ್ ಪ್ರೈಸ್ ಅಂತ ಮಕ್ಕಳು 3 ಸಲ ಕಳೆದಿದ್ವಿ, ಹೋದ ಸಲ ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. Yes, Venkash. Sorry. Sorry. ಎಷ್ಟು ಜನ ವಿಟ್ನೆಸ್ಗಳು?
Total number of witness. Number of witness. Not.
Three months later, you are abstaining. Wow. Ananda. Oh, ಗೊತ್ತಿಲ್ಲ ನಮ್ಮ ವೆಂಕಟೇಶ್ ದಳವಾಯಿ. Mere habitual appointment is not a ground to convict a 302. Only thing we should go by each case. ಇಪ್ಪತ್ತಾರು ಜನ ಇದಾರಲ್ಲ ಅಲ್ಲಿ. ಕಲಂದರ್ ಅಂಡ್ ಬಾಬು ಅಷ್ಟೇ. ಎಲ್ಲಿ ಓದಿ ಅಲ್ಲ, ವೇರ್ ದಿ ಲಾಸ್ಟ್ ಜಡ್ಜ್ ಅಪ್ರೋಚ್. ಇನ್ ಪೇಜ ಇಂಟರ್ನಲ್ ಪೇಜ. ಓದಿ. Jodi, on the evaluation of the evidence of the past witnesses. Para part Vodi. After careful scanning of the evidence of past witnesses, there is ample evidence brought on record that the accused committed murder of the deceased and prosecution proved this fact beyond reasonable doubt. Present evidence. The accused assaulted on the head of the deceased, deadly weapon like club. There is no doubt the intention of the accused was on the head of the deceased. Accused has knowledge that the injuries inflicted on him are so imminently dangerous that they must, in all probability, cause of death of deceased. The accused has knowledge, implies consciousness, further and consequence, so and so. He had knowledge and probability, so it is well settled that knowledge is so and so. What is the cause for death? Why you attacked? ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟು ಜಾಸ್ತಿ ಆಗಿ ದುಡ್ಡು ಕೇಳ್ದೆ ಕೊಡದಲ್ಲ borrowed 500 rupees loan from the accused. ₹500 ವಾಪಸ್ ಕೇಳ್ದ ಅವನು ಡಿಸೀಸ್ abused him in the filthy language, asked the accused which amount he has to pay him. ಹೋಗಲಿ ಯಾವ್ದು ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ ಅದಕ್ಕೆ be enraged by this act of the deceased, accused pushed the deceased forcibly in order to commit his murder. When CW18 intervened to rectify the quarrel, accused assaulted partly. They ran away from the pair. Accused dropped a fresh stone on the head of the deceased while laying on the ground. Therefore, on the base of the yes, what is your argument? Satiddu, homicide death is not dispute. Correct.
ರಿಕವರಿ ಏನಿಲ್ಲ ಇವನ ಹತ್ರ ಅಲ್ಲ ಬಿಡಿ ಇವಂದು ಬ್ಲಡ್ ಸ್ಟೆಂಟ್ ಕ್ಲಾಸ್ ಏನು ರಿಕವರಿ ಇಲ್ಲ ಅದೇ
What happened? Stone. Admel bread ilva. Then ಸ್ಟೋನ್ ಅಂದ್ರೆ ನೀವು ಇವನ ಹಾಕಿದ್ದು ಅಂತ ಯಾರು ಇಲ್ಲ ಅಂತ. ಏನ್ರಿ ಹೌ ಲಾಸ್ಟ್ ವೀಕ್ ಮೇಲೆ ಹೆಂಗ್ ಕನ್ವಿಕ್ಟ್ ಮಾಡೋದು? ವೈ ಯು ನಾಟ್ ಎಕ್ಸಾಮಿನ್ ದಿ ಪರ್ಸನ್ ವಾಸ್ ಇನ್ ಸ್ಪಾಟ್. ಬರೀ ಲಾಸ್ಟ್ ಟೈಮ್ ಥಿಯರಿ, ನೋ ಅದರ್ ಲಿಂಕ್, ನೋ ಅದರ್ corroborative evidence. ಅದಾಯ್ತು ಬಿಡಿ, ಎಲ್ಲ ತಗೊಂಡಾಗ ಹಾಕ್ಬಿಟ್ಟವ್ರು. ಅದಿ ಅವ್ರು ಬಾರಿ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು ನಮ್ಮವ್ರು ಪೊಲೀಸರು ಹೋಗ್ತಾ ಇಲ್ಲ ಅಂತ ಮಾಡ್ತಾರೆ, ನಾವೇನ್ ಮಾಡ್ತಾವ್ರು? ಅವ್ರು ಮೇರ್ಲಿ ಬಿಕಾಸ್ ಈಸ್ ಇನ್ವಾಲ್ವ್ ಇನ್ ಅದರ್ ಕೇಸ್, ಆ ಕೇಸಲ್ಲಿ ಒಳಗಡೆ ಹಾಕೊಂಡ್ರೆ ಈ ಕೇಸಲ್ಲಿ ಬಿಟ್ಬಿಡ. Whether only on the basis of loss in theory, without any other corroboration, can be convicted without link. This is only the based on circumstantial evidence. This is there not a direct evidence, no witnesses, only based on circumstantial evidence. Whether based on circumstantial evidence, only on the basis of loss in theory, can be convicted, that to 302, without there being any other corroboration. Is in custody from 2013. Except only corroborative evidence ಮೇಲೆ ಇದು ಲಾಸ್ಟ್ ಇನ್ ಥಿಯರಿ ವಿತೌಟ್ ಎನಿ ಅದರ್ corroboration. ಅದೇ ಕೇಸು
ಅಲ್ಲ, ಬೇರೆ ಕೇಸಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆಯಾ? ಇಲ್ಲ, ಅದ್ರಲ್ಲೆಲ್ಲ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಮಾಡೋಣ. ಎಷ್ಟು ಕೇಸ್ ಒಳಗಡೆ ಹಾಕೋದು ನಾವು? ಅದು ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ. ಏನು ಕಾಣ್ತಾ ಇಲ್ಲ, ಇದು ಜ್ಞಾಪಕ ಇಟ್ಕೊಂಡು ಅಲ್ಲಿ ಹೊರದಾಕ್ಬಿಡೋಣ. ಕರೆಕ್ಟ್ ಮೋಡಸ್ ಆಪರೆಂಡಿ ಇದ್ದಾಗ ದೇ ಆರ್ ವೆರಿ ವೆರಿ ಕ್ಲವರ್ ಅಕ್ಯೂಸ್ ಪರ್ಸನ್ಸ್. ನಮ್ಮವರು ಹುಷಾರ ಕ್ಲವರ್ ಆಗಿ FIR ಹಾಕ್ಬೇಕು, ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ನೋಡಿದ್ರ except the last week theory by PW1 and 2 and 4. What is the other evidence to indicate these people? ಅದಾಯ್ತು, ಬಾಡಿ ವಾರಂಟ್ ಅದು ನಮ್ಮವ್ರು ತಾಕತ್ತಿಲ್ಲ ಅಂತ ತಪ್ಪಿಸ್ಕೊಂಡಾಗಿದ್ದಾರೆ. Shivana would have been examined. Shivana is the eyewitness for the fighting things. ಅವನ್ನೇ ಮಾಡಿಲ್ಲ. ನೋಡ್ಕೊಳ್ಳಿ ಬೆಳಗ್ಗೆ.
ಆಗೋಯ್ತಲ್ಲ, ಹೇಳ್ಬಿಟ್ಟು ಇನ್ನೇನ್ರಲ್ಲ ನೋಡಿ.
ಕೊಡಿ ಕೊಡಿ, ಬೆಳಿಗ್ಗೆ ಕೊಡಿ. ಫ್ರೂಟ್ಸು ಅವ್ರಿಗೆ ಮೊಟ್ಟೆ ಒಳ್ಳೆ ಫೆಸಿಲಿಟೀಸ್ ಇದಾರ್ರಿ.